Once there was a pretty little girl who lived in a house that had a little garden. La, 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 la. They shared good dreams, secrets, memories, every lovely day to go down in history. Forever and ever, everywhere they go.
Hello and welcome to a special interview for The Wire. It's not at all common for a senior lawyer to write critically of the Indian judicial system, but that's exactly what my guest Abhishek Singhvi has done. In a book that's been recently released, and here it is, it's called From the Trenches, he's actually made some pretty striking comments about the Supreme Court, and they're not at all complimentary. The book, of course, is a collection of essays about 8 of his most interesting cases, but what stands out is the conclusion where he talks about the Indian judicial system, and in particular, about the Supreme Court. And that is the first issue I should raise today with Abhishek Singhvi. Mr. Singhvi, you say of the Indian judicial system, and I'm quoting, our court system is not in good health. And you then say the quality of trial judges is generally poor. That means that at the very first point of contact with the judicial system, an Indian citizen doesn't stand much of a chance of justice.
Let me start with a quick caveat. I have spent a lifetime in this system. I've seen it close quarters in different capacities. So generally, I know a lot about it and I have a lot of faith in it, especially relative to other organs. So when I criticize it, it is really constructive criticism. But to answer your question specifically, I have to sadly say that given the quality of trial courts in the 50s and 60s, and now there's a huge deterioration. Given the quality of trial court judges in the 90s and 2000, there is a further deterioration. And I think scholarship, I think the ability to be able to put it correctly, to go to the heart and nub of an issue, and to be efficient is something which is going down. And that's a fair comment. It's not meant about individuals, but I think the way the system functions, and yes, it hurts more because it's the cutting edge of your first interface with a common man.
Precisely. It means at the very first point of a common man's contact with the judicial system, he can't be certain of justice.
I wouldn't say justice. You see, you may be making bona fide errors. You may be making, so you are trying to do your justice. But if you're not efficient, if you can't handle the workload, if 25% of our 21,000 posts of the lower judiciary are vacant, then with the best of intentions, your path is paved to hell.
But you're simply saying what I said in a different way. As far as the common man is concerned, whatever the explanation, he doesn't get justice.
The result, you're right. I'm just saying, it may be a bona fide error, but the result, you're right. The result is that.
And in fact, then your book points out that things don't get appreciably better even at the High Court stage. Again, I want to quote you, a High Court judge has to handle more than 50 matters a day. And it requires a superhuman effort for a judge to keep track of so many hundreds of matters a week, to remember the facts, to hear arguments, and ultimately to write a well thought out, reasoned order which balances the rights and does justice. So once again, the odds are against a fair and proper judgment.
Karan, you have touched upon my favorite subject. For over 25 years, I've been writing on the battle of the bulge, the beating the backlog syndrome. We have the finest judiciary, the minds, the doctrines. We are the inventor of a doctrine which says a constitutional amendment is unconstitutional. We have PILs, and yet we hang our head in shame because of what you just mentioned. Just two quick statistics. How can you expect a system to work? And what you just read is understatement. With roughly 40% of all High Court judges at any point of time since independence till today, any point of time, being vacant. In a country of 1.2 billion, assume a 33% litigating public, you have 400 plus out of 1100 High Court posts vacant. Now, how is it possible for any judge to even come to grips with a person, give a quality of hearing, and then decide the matter? If 40% of seats, do you know that there are High Courts where, like Allahabad, where 100 seats were vacant out of 160.
But Mr. Singhvi, it's not just the vacancies that create a problem. I want to go back to what you've written. It is a superhuman effort required for a judge to keep track of so many hundreds of matters a week and then listen to what you say, to remember the facts, to hear the arguments, and ultimately write a well thought out, reasoned order. That suggests that the odds are against a fair, proper judgment. It's just superhumanly impossible.
Why? Your
because
question
he's
has to
got
be
too much
answered.
work.
Why? You have too much work because in your court, you are 1 out of 160 judges in Allahabad High Court. For years, you did not have 100 people sitting. Now, the litigator who comes, he loads your court with 100 cases, whereas you should be doing 40 cases.
I accept your explanation, but the point I'm making again is similar to the one I made about the trial court. Whatever the explanation, as far as the ordinary Indian citizen is concerned, once again, the odds are loaded against him getting a proper judgment.
The odds are loaded, and there are many more reasons. We have to look again. Certainly, the odds are loaded. Why? Also, we had till a few years ago 13 judges per million of population. The average, the good figure for USA is 50 judges per million of population.
Too much
France,
work and too few judges.
France, etc., aspires to 35. We have crawled by a constant repeated danda of the Supreme Court from 13 to 19 in 20 years.
This is one further reason why an ordinary Indian applicant, even at the High Court level, will feel the odds are loaded against my getting a proper judgment. And then you identify one further reason, which actually is particularly worrying. You say judges have a penchant or a tendency to keep granting adjournments. You write, there is a tendency to decide hard questions by adjourning them, which means judges either kick the can repeatedly down the road or they wait for the outcome to be determined by fait accompli.
Well,
and neither is justice.
Just to simplify it, one set of category of reasons is simply adjournment. You are lazy, you are inefficient, you are overcrowded, you have too much work, and you have not yet learned. And of course, the counsel always, because one side in a dispute is always wanting an adjournment, helps that side. So you are not. One second.
One reason you said is because you are lazy and inefficient. Judges being lazy and inefficient would be deeply disillusioning. You're acknowledging it, some of them are.
Certainly, you cannot say there are none. But I'm saying the more greater category is different. I was coming to that greater category. That's fortunately a small minority. What is happening in the other cases? There is always one party to a dispute, A or B, which wants adjournments, which wants delay.
But judges can refuse.
Exactly. Now, they have not used the great weapon we have, the Brahmastra of costs. Judges have this from 200 years, 150 years in our civil procedure code. But because of not wanting to be unpopular, because of not wanting to antagonize the bar.
Not wanting to be unpopular?
Not
Why
antagonizing the bar.
Worry about popularity?
Because
it's not a beauty
they
contest.
function in a system. They believe that if we impose costs, if you impose heavy costs, adjournment will stop.
But again, I'm interrupting you because you're giving me 2 or 3 further reasons why the audience will say, do we really have good judges? A, judges don't want to be unpopular, but this is not a beauty contest. They should risk unpopularity to give justice. And secondly, if they have the power to impose costs to ensure that, in fact, the trial happens speedily, they should. By not doing it.
It's an underutilized weapon. It should be used much more.
By not utilizing that and by caring too much about their personal popularity, which frankly is an irrelevant concern, what happens? They kick the can down the road repeatedly, or the outcome is finally decided by fait accompli, and neither is justice.
You're certainly right, but then the point is we have to look at all these causes holistically. There are good judges who do 10 times the work they should be doing. There are judges in India who in 1 week do the amount of work which US and English judges do in 1 year.
But that's even worse.
I'm talking the whole system.
You're saying for the applicant like me, it's the luck of the draw whether you get a good judge or a bad judge.
Obviously,
if you end up with a bad judge, you're sunk.
Well, obviously.
But then that again suggests that there's something terribly wrong, not just at the trial court level, but now we're saying even at the High Court level.
I think it's a structural problem we have.
Whatever the cause.
All levels of the courts. Because you simply have a system, allow me to just finish. A, overcrowding of cases. B, insufficiency of judges by 50%, 40%, 60%. C, not being able to use weapons which you already have.
What do you mean not being able to? Not willing to?
Not willing to for a variety of reasons.
And caring too much about your popularity, which is irrelevant.
And D, some of the arcane procedures we have, some of the arcane compulsions we have. I have to follow a system of notice. The notice is very long. The notice is not served. Emails start being used now. So all this combines. It's not one.
But
all
the worst part was when you suggested that some judges don't actually speed up cases because they don't want to become unpopular. And that's the most disillusion.
I mean, it's not as much as you repeated so many times, it's the primary reason. No, but it is a reason.
Absolutely.
It's a personality-based reason. And ultimately, costs pinch and you start with low costs, and judges have tried it in the high courts, then you grade it up and adjournments drop by half. It doesn't mean I have to impose a lakh cost.
Except that
now the
judges
Supreme Court
don't do it. And if you have a power which you can use and that would ensure justice and you don't do it, then actually your failure to use it is ensuring the opposite, injustice. People are suffering.
I think you're right in the case that it happens.
But your most trenchant criticism is actually when you come to the Supreme Court level. And there first you say, I'm quoting you, the Supreme Court has in the past few years, in matters where there are great stakes involved, shown a reluctance to act against the government. And if you look at the way the Supreme Court has handled just in the last 6-7 months, either the CAA cases or the Article 370 cases, you're absolutely correct. And if you compare it to the speed with which the British Supreme Court handled the critical constitutional matter of the challenge of Boris Johnson's right to prorogue Parliament, there's a world of difference between our Supreme Court and the speed or the lack of speed and the British Supreme Court.
Partly you have to realize that the English courts have far less workload, so they are able to prioritize, no doubt about it. But then equally, the high courts, which are superior courts in India, and the Supreme Court must know that despite their back-breaking schedule, they have to take out of turn matters of great significance in the moment.
That's the essence of justice.
That's just a question of priority. You have to decide that every case is not equal.
But Mr. Singhvi,
that's the good or the bad part of it.
Prioritization is the essence of justice. What is critical you do first,
it is.
And unfortunately something then falls back as a result.
And sometimes, this is one reason, sometimes of course I must add, and fortunately it's very rare, I'm still very proud of the Supreme Court, I'm proud of our high courts. We're all talking of aberrations. Don't say it as if it's the norm. It is fortunately an exception. It's an exception.
These aberrations are happening so often today, they are becoming the norm.
No, fortunately they have not become the norm, but the aberrations must be recognized and checked.
But just
and the reason I'm saying, let me explain the aberration. The aberration is another category which you'll find more interesting.
No, hang on, I'm going to interrupt
avoid the issue.
No. Avoid the issue is precisely what I'm coming to. I want to look at the reasons the Supreme Court gives for actually not tackling matters which quite often they should give priority to and take out of turn. Let's first take up CAA. Chief Justice Bobde has said in court that he won't come to the CAA petitions that are before him until the protests end. As if somehow he's suggesting that good conduct is a prerequisite.
No,
Let me finish and then you answer. The truth is that actually it should be the opposite. Often when courts agree to look into matters, public agitation calms down. Here, the Supreme Court, or Justice Bobde in particular, seems to be suggesting that until the protests end, he won't go into a critical constitutional matter.
I think you're wrong there, Karan.
I'm quoting him.
No, I think you're wrong.
I'm quoting him.
First of all, my book is not about a particular case.
I know it's not, but I'm quoting Justice Bobde.
Allow me to answer, Karan. Allow me to explain. You are now again doing the same thing of speaking more than the interviewee. Let me allow you to explain. Justice Bobde has not said that. In fact, I'm in the lead matters in that matter. He has put the matters for hearing. However, the problem is that he put the matters for hearing and they will come only if we are lucky in April. In between, allow me to finish. I'm giving you facts of this.
If we are lucky in April.
In between, a very important religion matter of 9 judges came up. That might have, half of it might have been over. In fact, the original plan was to finish it by 6th of March. 5 judges fell ill, 2 of which were on that bench. So that thing got postponed, which postponed CA further. Incidentally, what you said, that we will deal with the matter when normalcy comes, is what is said by the government in Parliament.
Just a moment.
Not in the Supreme Court.
You're actually mistaken. I don't want to quarrel with you over this. If you go back to the papers, you will see that actually Chief Justice Bobde has actually said that he will attend to the CA cases after the protest.
I'll tell you why
it was in the papers.
I'll explain to you why.
Let's not quarrel on that because that's an irrelevance. It's a side detail.
It was the interim order application in a particular case where he said we'll now hear it 2 days later when things quieten down. For the main hearing of the CA, he has fixed April.
But there's a bigger issue here.
I think it should be made sure that it starts then.
Let's not get into side details. Even the other argument that you made, that because there is a 9-judge bench hearing the Sabarimala case, this can't be taken up. I take it and put it to you that this is of far more fundamental importance than Sabarimala. And the judges should have actually said, we have to give this priority. Yet not only have they not, the Chief Justice has, in his rhetorical comment, which he may not have meant, has actually given priority to good conduct as a prerequisite. Chief Justice Shah of the Delhi High Court made that point to me. I'm only quoting him.
There is some degree of force majeure. Because I'm appearing in both those cases. The religion matter would have been over by 6th of March, I repeat. Because of this postponement, it's got postponed by 3 weeks more at least. if the CA matters don't start in April, they could have started in March, I agree, but for this force majeure.
They should have started in December.
But for this force majeure. If they don't start in April, then we are in trouble.
Forgive me,
but
they should have started in December.
We need to give time till April, because they were intending to start it in February,
I see
March.
no reason why you need to give the Supreme Court time till April or even March, when the issue concerns not just a critical constitutional matter, but is creating tremendous tension in the country, which they were aware of. It should have started immediately. The duty of the Supreme Court is to give timely justice.
In principle, I agree with you, but given the crowded calendar, 2 months I wouldn't have minded, but now it's got 4 months.
It's not a question of
it's
your
now
minding.
Become 4 months.
It's not a question of you personally minding.
I'm saying I'm giving my opinion. I'm giving you my opinion that 2 months would have been understandable with the crowded schedule they have. But unfortunately, circumstances have conspired to make it 4 months. I am repeating that because of this postponement, in any case, it must start and finish within April, because then the holidays will start.
Just a moment. Let's take up another example of the Supreme Court deliberately and repeatedly delaying a critical matter. I'm talking now about the Article 370 cases. They've been repeatedly not taken up. And in fact, one occasion, the then Chief Justice Gogoi said, it doesn't matter, we can wind back the clock. And I put it to you, justice consists of timely delivery of justice, not repeatedly finding reasons and excuses to keep deferring matters.
I'm making a significant comment which you might or might not like. I have sadly to say that avoidance or postponement of some of the oversensitive critical issues did happen much more with greater frequency in the previous judicial regime. It has not yet been so reflected in the current regime.
Do you mean the Gogoi regime?
The previous judicial regime.
Is that the Gogoi regime?
And not the current judicial regime.
But to be clear, do you mean under former Chief Justice Gogoi?
Well, judicial regime is defined by the Chief Justice. The previous one was Justice Gogoi. It has happened in many cases. One of them is what you are mentioning, and it should not have happened. I don't think blame can be laid in the current regime yet. Yes, if we don't get down to the teeth of the CA, yes, you would be right to blame them.
Just a moment, this is very interesting. Hang on, let me, you're
370, one more thing, 370 got entangled further in a preliminary issue. They started saying that you first decide whether 3 judges or 2 judges, fresh reference to be made to 7 judges.
You're so
and therefore today, they have given a judgment, or yesterday,
so understanding
which again prolongs
of the Supreme Court suddenly, when I'm pointing out their lapses, how then do you explain your own sentence? The Supreme Court has in the past few years, in matters where there are great stakes involved, shown a reluctance to act against the government.
You didn't hear my last sentence.
Which is what?
This allegation, and especially when this book was written, is precisely 80% more against the previous judicial regime. I'm very frank about it.
Hang on, let me then give you an example from this judicial regime.
Yes.
I'm talking
this
about something that happened.
I'm
talking about something that happened today, Wednesday, the 4th of March, and it concerns, in fact, Chief Justice Bobde. He publicly said in court that he would not consider Harsh Mander's petition about hate speech and taking action against hate speech until he had got clarity about an alleged criticism that Harsh Mander is supposed to have made of the Chief Justice. And what does that mean? That he gives priority to sorting out a criticism made personally either about him or the Supreme Court as a whole, which is a matter of their personal reputation, let me finish, rather than giving priority to hate speech, which has an impact on people's lives and which is creating tension. I put it to you, that's a very peculiar sense of prioritization.
Let me give you my view on this. I don't think that the Chief Justice has refused to hear or avoided the Mander issue.
I didn't say he had.
No, allow me.
He said he'd do it only after he got clarification on Harsh Mander.
I think the problem there arose because the Delhi High Court was grievously in error in giving a long date of postponement. I believe that date has been preponed. Now, it
there
is
are two different matters. You're clubbing them together.
No.
The Delhi High Court has been told to begin hearing from Friday. I'm talking of a different issue. Harsh Mander had a separate application for hate speech regarding 3 people in particular, I believe.
Yes.
Anurag Thakur, Pravesh Singh Verma and Kapil Mishra.
Yes.
And to that, which is a separate matter, Justice Bobde is reported by the television channels to have said he will only take it up after he gets clarification of an alleged critical comment made by Harsh Mander. And he's asked for the transcript of Harsh Mander's speech. And I put it to you.
This I don't know about whether he is saying about himself. Is the critical comment about the Chief Justice of India?
No, as I said, the critical comment is about the court. And the Chief Justice wanted clarification and he's asked for a transcript of this speech.
No, I think I frankly don't know the facts of this case
Let me give you the facts.
But in case it is so, The Chief Justice is within his right to ask
Of
for
course,
1 day.
he's within his right.
And he's within his right
but
to wait for a day.
But the priority behind it is what I'm questioning. That you give greater priority.
He's not postponing it by weeks.
Hang on.
He's waiting to hear him.
He's delaying it. No, he's not even willing to hear it. He says first he wants clarification. And let me put it to you that the priority in his mind is first clarify a criticism made of the court, then I'll attend to hate speech. Whereas most people would say, a criticism of the court is a matter of personal reputation. Hate speech affects the country. Surely hate speech is more important.
I don't think he's done that. It's the hate speech which he has preponed. It's been preponed.
No, you're talking about two different cases.
No, 1 minute, sir.
They're two different cases.
Two different cases about the same person, the same hate speech. Let's get that clear. The Delhi High Court preponed about the same thing. That Supreme Court has done. 2, he's entitled, I repeat, he's not given months. He's given a few days to find out whether there is possibly contempt of court or critical, in which case he might not want to hear. He might give it to another bench.
Let me tell you what
let me
come to that point. Let me tell you what the channels are claiming was said by Harsh Mander that the Chief Justice has apparently, allegedly taken objection to. He said, apparently in his speech, he has no faith in the Supreme Court. Why is that such a terrible thing to say?
Well, it is a contempt of court.
Why is it contempt of court?
It can be.
It don't mean it can be. Yeah. There are loads of people who say they have no faith in the judicial system.
That's all right, but if you are litigant standing there and you are liable to say that you have no faith in the Supreme Court, the court can say that either you decide whether you have, and otherwise I'll send it to another bench.
Just a moment. Apparently, this speech was made in January. Harsh Mander only became a litigant sometime at the end of February. So the comment was not made in this context, it was made in January.
You are now talking of an actively sub judice matter which happened today. I don't know the facts.
It seems to me.
He's not avoiding the issue.
I'm not saying
he's not saying that he's not going to decide the matter. He's entitled to seek clarification and go on to decide the matter.
Let me give you a third example to illustrate the point you made about how the Supreme Court damagingly keeps deferring things. Look at the habeas corpus petitions, starting from Kashmir onwards, that keep getting deferred. They get heard eventually, but they get deferred repeatedly.
I've said so in my book.
And isn't it worrying because habeas corpus concerns the right to life? It should be the Supreme Court's first priority. It falls instead to the bottom of the agenda.
A time has come when somebody has to sit separately to simply prioritize, because it's a given that you cannot do all matters. Now the prioritization has to be ad hoc. It will not be liked by you or me. But that there is a prioritization, I 100% agree. It's not happening. Now you are, for 3 reasons, either because of overcrowding, or innocently, or bad management, or simply not aware. Lax cases are filed, don't become aware. But 4thly, where matters are of critical moment, where push comes to shove, when some very important government issues involved, you may just postpone it because there's a result by default. Now, I don't agree with that at all.
No, you may just postpone it because you're actually unwilling to give a decision that goes against the government. That's actually the sentence I want to quote, because I believe that on that section where you're criticizing the Supreme Court, this sentence is possibly your conclusion. You say, my fear is that the judiciary has lost some of its independence and the fearlessness that it needs to check the executive and the legislature. And let me finish. That clearly suggests to me that you think judges are becoming pusillanimous, and secondly, they're taking political sides.
No, I think you're of course rewriting my paragraph, but 2 or 3 things.
When they've lost fearlessness, aren't they becoming pusillanimous?
As a matter of fact, this para is very interesting because it actually contrasts and suggests an improvement. Because I am saying that this position, which was in the previous judicial regime, has improved. This is my view. I'm answering your question. This was certainly more truer for the last 3 or 4 years. I have criticized it elsewhere. I think between December and now, we have not seen any egregious example. There have been delays yes, but there was possibly a deliberate avoidance of issues. There was a fudging of issues. There was a kind of putting it in a thanda basta situation, which I don't agree with.
You're really critical of the previous regime. You're really critical of the way Justice Gogoi conducted the court.
I'm not.
The priorities he said.
I'm not talking of it, but yes, the impression was there that many cases which deserved immediate attention were not given attention.
So Justice Gogoi was the person under whom the court kept
I have said just
avoiding
now,
tough issues.
The frequency of such events in the previous judicial regime has been far higher than the 3 months we've had of this judicial regime. In fact, I'm not saying about tomorrow, but we've had only 3.5 or 4 months.
But your comment that the judiciary is losing some of its independence and fearlessness is about the court under Gogoi.
Yes, mostly. This book was written at that time, this chapter, and you must realize that if you have something for 3 years or 2.5 years, that effect shows now. Now, that effect will lie. Today, You have to do things in a different way to take away that impression.
Let me put something to you, because the conclusion that comes to my mind is that it's not just at the level of trial courts that the quality of judges is poor. That's equally true of some judges at the Supreme Court.
Well, if you say some judges, certainly. How can I disagree with that?
In fact, I'm going to go one step further. The two qualities you admire, independence and fearlessness, are actually character qualities. Some judges have them, some don't. Quite clearly, you're suggesting to me, Justice Gogoi did not have them.
No, I don't think you should draw such a sweeping conclusion. I have not mentioned any name.
But you said the previous Supreme Court and you agreed it was under
every
Gogoi.
institution, from President of India to Prime Minister to downwards, it depends on the person. Institutions don't make, the person who occupies them makes the institution. Now certainly these are character qualities. To this you must add scholarship as a third very vital ingredient peculiar to judges. Certainly they vary from man to man, person to person, woman to woman. Certainly there has been a decline in many cases, and certainly the frequency and the overall impression of this decline in the preceding 2 to 3 years is more than the preceding 4 months.
Let me
That's a fair conclusion and a straightforwardly stated conclusion.
Let me at this point raise something that has happened only in the last 6-7 days. Clearly it's not in your book, but it is germane to what we're talking about.
This is about 3 months ago.
Just a moment.
Yes.
It's germane to what we're talking about. The deterioration in the quality of judges and the absolute critical need for judges with good character. I'm referring to Justice Arun Mishra, who publicly has called the Prime Minister a versatile genius, who publicly said that Mr. Modi was an internationally acclaimed visionary. To me, the quality you value of independence has been converted by Justice Mishra into sycophancy.
I don't accept your words, but I have openly said, and I agree with you, that a sitting judge, whether he means it or not, whether he intends to say it or not, just should not say it. A sitting judge is as much about perception as about reality. I may be completely real in X form, but if my perception is Y form, it compromises my independence and integrity. Now, Justice Mishra, I don't know what he meant, but he could easily have avoided it. And I think there is a properly worded, dignified reaction from several quarters, including from senior advocates like myself, where the message has been sent that irrespective of your leanings, you have to simply curb yourself. After all, that old saying that you have to be, if not a nun behind cloistered shadows, you have to be at least a recluse to the extent of participating in a political debate.
In fact,
those words, I think, could have been easily avoided, and perhaps, to give the benefit of doubt, might have been unintended or come from somewhere, but they need not have come at all.
The problem is not just the words. The problem is the attitude that was given expression to by those words. The attitude of Justice Mishra is not of objectivity, it's not of impartiality, it is of preference and partisanship. That attitude leaks through this language.
No, I would not agree with such wide words for a sitting judge to suggest that there is this kind of bias at all. All I am saying is it was inapposite.
This smacks of bias.
I am saying inapposite for a sitting judge to use these words at all. I would think that most of the brethren share this view. Most of the people in the legal community share this view, and perhaps somewhere he himself would share this view that it might have been avoided. Sometimes words leave your mouth, they come in a speech, they can't be taken back.
Can I at this point quote to you point number 16 from the 1997 Charter on the Restatement of Values of Judicial Life, which the Supreme Court created for itself.
You don't need a restatement, Karan. You should not just say these words. They are simple as that.
Let me quote point 16 because I think it's important the audience should hear it. Every judge must at all times be conscious that he is under the public gaze, and there should be no action or omission by him which is unbecoming of the high office he occupies and the public esteem in which his office is held.
There is a reality and a perception intersection which is both
Justice Mishra
fatal.
drove a coach and horses through this with his eyes wide open.
I would imagine, I don't know, perhaps we'll ask him after he retires, he himself would not have wanted this to happen. It has happened, can't be helped. Now, if somebody was to give a clarification...
What do you mean he himself would not have wanted this to happen? He spoke the words.
No, I'm saying that possibly this is something so obvious, I don't know, I have not talked to him, he's not said so. I'm saying this is something so obvious should not have been done. Something so obviously which should not have been done that everybody would regret it.
This is a very, very strange defense. When you say that Justice Mishra himself would not have wanted this to happen, you're suggesting that he didn't realize what he was saying, that he spoke ineptly. The words slipped out of his mouth.
No, I'm saying the obviousness of the error is so much that anybody would regret it. That's what I'm trying to say. And I don't think...
But he ain't regretted it so far.
I think for him to now publicly regret it would make things worse.
But hang on.
It's over. Now, at some point of time, I'm sure he'll clarify.
There is nothing wrong in a judge saying, I'm sorry, with hindsight, I made a mistake. He'd go up in public esteem instead of being arrogant and defending a mistake as if it wasn't a mistake.
Different people react differently. All I'm saying is, my words are not your words. My words are, it's inapposite, perceptually wrong, should not have happened.
But this example, which you could never have foreseen when you wrote your book, actually proves your point that judges are losing something of their independence and fearlessness.
A great judge,
they've become sycophants.
Intellectually a giant like Justice Bhagwati made the error of writing a letter to the then Prime Minister. Now, according to everybody, the admirers of Justice Bhagwati, and I'm one of them, he should not have done it at all. This I'm talking of 86 or 85. Now, this is the kind of self-imposed restraint and discipline which you as a judge have to exercise. Words shot out, they can't be retrained. And that's a perfect example, just Bhagwati's example.
Let's at that point take a break. When I come back in the limited time available, I want to discuss with you the Sabrimala judgment. You've devoted a whole chapter to it in your book. It's one of the most interesting judgments because it raises critical issues that need a lot of thought. But first, we're going to take a break and listen to a message from our sponsor, Glenlivet, whilst I have a reassuring sip from this glass.
Take a little trip with me, I'm gonna take you home.
Take a little history.
Take a little
down this lane of memories.
down this lane.
So let's raise another glass for the glorious past and the friends we have become. Yeah, 'cause little did we know the good times come and go, but the best is yet to come.
Welcome back to a special interview for The Wire. My guest is leading Supreme Court lawyer Abhishek Singhvi, who's just released this book, and here it is, From the Trenches. And he has a very interesting chapter on the Sabrimala issue where he was the temple's lawyer. And that's the issue that I'm going to discuss with him now. Now, you were not just the temple's lawyer, but your argument hinged very often on Article 26 of the Constitution, which reads, subject to public order, morality and health, every religious denomination or any section thereof shall have the right to manage its own affairs in matters of religion. Most people would say that the Sabrimala rule that disallows women between the age of 10 and 50 to enter the temple, because that's the menstruating age for women, is morally unacceptable and clearly, therefore, falls foul of Article 26. You completely disagree. So can you begin by explaining why is that rule not morally unacceptable?
Yeah, two clarifications at the outset. Don't think that a lawyer chooses his clients or judges his clients. I am the lawyer. It always doesn't mean that I believe in the client stand. But in this case, I do. Secondly, this is one of those two chapters in this book where things turned like a pendulum ding-dong. We lost the Sabrimala 4-1. When this book went to print, we, in a sense, won Sabrimala on the review.
You haven't won it.
On the review, I said.
You haven't won it.
On the review, I said. Review means reopening. We had lost it finally.
Yeah, but you don't know what the outcome will be, so don't say you won it.
We won the review because that's the reopening. There's no reopening of the case otherwise. The matter would end.
Oh, hang on.
And then when the matter went to print.
Reviews are often rejected. The track record of reviews is rejection.
That is why this is allowed. The review is allowed.
But come back to my question.
Now,
why do you believe that the Sabrimala rule is morally acceptable?
Reopened the matter with a review. And thirdly, when the book went for print, we were about to start the 9-judge hearing with me as the second lead counsel, but the matter got adjourned because of illness in the bench.
But now, having said the caveat, question, why do you believe the Sabrimala rule is acceptable and not unacceptable?
Yes. Sabrimala is an important issue which is not understood, and it has to be a little technical. Sabrimala seems on the face of it that there is an exclusion of women. This has nothing to do with women. There is an exclusion of women between menstruating age and also of people who don't do vratam. The classification is between men who can go provided do vratam and women less than 10.
What is vratam?
Vratam is severe penance for 41 days. They must abstain from sex, they must abstain from certain kinds of food, men as well as women, or the women must be less than 10 and more than 50. Now, what seems like an arbitrary gender exclusion has to be seen in terms of Article 25 and 26, both of which go together. That Ayyappa Sabrimala is the only temple out of 1499 temples in this country, or 1500 temples, which celebrates Ayyappa, Lord Ayyappa, in the form of the eternal brahmacharya, Neshtik brahmacharya. If an activity, the only temple which celebrates him in form X, if an activity is supposed to be fundamentally antithetical to that form, then 25 and 26 protects that activity, provided it arises from religion and is a religious denomination.
Hang on, just a
if
second.
it is no religion and denomination, then no.
It is the only Ayyappa temple that has this particular practice. All the other Ayyappa temples do not.
That's the point.
And therefore,
that's the point you're making.
saying that one single temple becomes a denomination.
Yes.
The judges questioned that. The judges questioned that and didn't agree with you.
Obviously, that's why the review has allowed us now to re-agitate the question.
And the judges therefore believe that this practice by the temple amounts to, in fact, something that comes under 26,
your question is a little different.
To morality.
Assume it's a denomination. See, if there's not a religion and not a denomination, matter is out. Now, if it is a religion or a denomination, in our case it's a denomination, the Ayyappan denomination, then something antithetical to the nature of the deity can be excluded by religion, which cannot be judged by objective standards of what Karan Thapar and Abhishek Singhvi think to be the right conduct of women. It has to be by the subjective standards of those who practice the denomination. That's the meaning of 25 and 26.
Let me take you up on the question of morality, because in your book, you say the following, and I'm quoting.
Morality doesn't mean what you're saying.
Just a moment. Can I finish my question? This is what you write in your book. There is no question of morality which has been understood to be something as offensive to human nature as cannibalism. I put it to you, there's an awful lot, short of cannibalism, that society thinks immoral. You've excluded all of that. You only think things are immoral at the level of cannibalism.
No.
That's a weird argument.
If see, the test of 25-20, you have to be legalistic to discuss this, you can't be general. The test of 25-26 is A, identify if there is a religion or religious denomination. B, is there a religious practice part of that? C,
one single temple creates a denomination?
Karan, if I can't explain to you any number of, what is the meaning of denomination or sect? Even sects are recognized. Ayyappan sect of Sabrimala is a special denominational sect. Obviously, it will depend on the Supreme Court accepting it. We are still in the middle of a review. But if there is no sect, the matter is out. But today, you are challenging it not on the ground of sect. You are saying, this is supposed to understand this nuance, assuming it's a religion and a sect, I, Karan Thapar, Abhishek Singhvi can decide that to exclude women of 10 to 50 is abhorrent, is immoral. That's precisely the subjective view which 25-26 permits as per adherents and practitioners.
Wait, hang on a second.
You are imposing an external objective standard.
I see no reason why an external moral value cannot be imposed upon a religion.
Unless it comes.
Can they be finished? I see no reason why an external moral value cannot be imposed upon a religion to make sure that it's in conformity with the Constitution. They've done
not
it.
With the Constitution.
Hang on a second. They've done it in the case of untouchability, which was intrinsic, many people believe, to the Hindu faith. They did it earlier under the British in the case of sati, which many people believe was intrinsic to the faith, although that happened in the 19th century. I see no reason why the Supreme Court can't say...
Exactly, you are making my point without realizing it.
That the Supreme Court position that this is immoral.
You are making my point, Karan.
I'm not, I'm making the opposite point.
You are making my point. Allow me to demonstrate it. You have to give me a minute, because you having the mic, don't allow me my minute. You have made exactly my point. Why is untouchability not allowed to be practiced in a temple? Suppose a religion says that you will not have untouchables. Why is it allowed to be not practiced? Because a constitutional amendment prohibits it.
That's right.
So, no problem. Does the constitutional amendment prohibit 10 to 50 women going? Or does the constitutional amendment allow them? Number two, please allow me. So long as you don't fall within the exception of public order, morality and law and order.
But you do. Morality is what you fall under here.
This is not the morality, sir, which you are talking about. It is not the morality of an external standard. Morality is which is an established, for example, nudity, pornography. Things which are standard by law. The example you gave about sati, an act of parliament was passed. The point is that external subjective viewers cannot decide that I find it abhorrent that women of 10 to 50. Let me ask you a question.
No.
Do you know any women, forget Sabrimala for a minute, do you know a large number of women who, and I am not giving the same example, I know it's optional, a large number of women in India who on their own voluntarily don't visit temples during menstruation? Why? Because it's a belief. A very large number of women.
But they're free to do so if they want.
Exactly. So I said this is not an example.
Here in Sabrimala, you're not free to do so.
Because this is the only temple which celebrates an eternal brahmacharya model which is antithetical to the fertility concept of women.
And the two things that I've questioned are this. I'm not going back into the debate, I'm just saying it for the audience so that they are clear in their mind. The first thing I've questioned whether
Article 17 prohibits untouchability.
it is a question of morality that women are barred or not. Many people would believe it is immoral and unacceptable to bar them. And the second thing we've questioned whether a single temple can be a denomination.
No, but Karan, they are not excluded. They are not excluded because of morality. You understand? Automatically, if it is found it is hit by public law, order, morality or law order, it's out. This exclusion not because of that. This exclusion is by the view of judges that certain things we find antithetical to A, constitutional morality, which is invented in 1 minute.
That's what I was coming to.
Now, there is no such concept except by judge-made law, which we are challenging.
But hang on a second. That's the issue I'm coming to, because Justice Chandrachud, who many believe wrote the judgment, actually raised the issue not of morality under Article 26, but constitutional morality. And in your book, in this book, you actually question the validity of constitutional.
And
why?
Yes,
clearly the preamble establishes constitutional
morality. This is an intellectual
morality.
debate. I am not right, he is not right, the court will decide. But just listen to the intellectual nuance of it. Constitutional morality is an unknown phrase in the Constitution. It came for the first time in a case called Manoj Narula by Justice Deepak Mishra. It's been followed only by 2 judges in several cases.
Freedom of speech of the press was also not in the Constitution. The judges brought it in. Karan, they can bring this in too.
It cannot, I am disabled, I am one-sided, I can't argue with you because you don't allow me to make my point and you go on making your points. Constitutional morality is it's an unruly horse. Constitutional morality is an external standard imposed by judges, not permissible in 25-26. Constitutional morality is a phrase taken from a debate of Ambedkar in the Constituent Assembly debates. If you see the whole passage, which you have not seen, the passage is about Ambedkar saying that I'd rather have the Constitution not with nitty-gritty details, but I cannot rely on the constitutional morality of the legislature. So I have to put all the details in an elevated document like the Constitution.
Can I interrupt you there?
So Ambedkar used the phrase in a totally distinct concept, distinctive concept to suggest that legislatures may not have constitutional morality in the future, so I am putting nitty-gritty in the Constitution. That phrase, according to me, I can be wrong, is wrongly picked up by Justice Deepak Mishra and Justice Chandrachud to make a new doctrine which is beyond the constitutional text of public order, public morality and law and order, not permissible as a derogable standard. Not permissible.
Let me respond to the intellectual argument. The Constitution is bound by its preamble, which sets the tone for the Constitution. The preamble identifies 4 critical principles that are at the very heart of our Constitution. They are justice, liberty, equality and fraternity. Those 4 together constitute constitutional morality, and all 4 are breached by the Sabarimala rule that women between the age of 10 and 50 can't go. So when Justice Chandrachud says constitutional morality is another grounds for striking down the Sabarimala practice, he's going on this basis.
Now, you can say that possibly if you're in a vacuum. Can you say it in an occupied field of 25-26? You have the exact words of an article which occupies the field. You here give an unruly horse, what I call a chancellor's foot, which varies in size. If you are the judge, your notion of those 4 words in a preamble override the 3 words of a constitutional text in 26. My notion as a subsequent judge sitting 2 years after you will be totally different. So constitutional morality will become nothing but the injection of the subjectivity of a judge. Well, we are challenging that in the 9-judge bench.
The subjectivity of a judge, which you refer to as the chancellor's foot using the British term, is actually something that runs right through judgments.
Not when the field is occupied by a constitutional text of 26.
It does there too, because it depends upon how they interpret those articles.
Right, but don't use the external word like constitutional morality.
Even when judges, as we discussed earlier, repeatedly defer critical things, there's an element of subjectivity behind the deference, and there is an element of the chancellor's foot. So if you can accept it there, you can accept it here.
No. Humanity itself is subjective, no doubt about it. But we are now talking of giving a leeway on general words which cannot override specific words of an article you are interpreting. You see, if the field is unoccupied, if it's a virgin territory, you can use the preamble words, you can use the doctrine of constitutional. But when the Constitution says I can derogate only on 3 grounds, you are derogating on a 4th ground, which is not defined in the Constitution, which is not intended by the framers. And Ambedkar's speech, incidentally, you must read that, is using the phrase which is picked up by the Supreme Court in a 180 degrees different concept.
This is something that the Supreme Court will decide. The review has been admitted, but I want to raise one more point you make in your book about the Sabarimala judgment, the one that's now under review. You say the court was under tremendous pressure from the media. There was no way to give another verdict without being painted as regressive. The press set standards for the court, and I believe this was definitely a factor in the way the court
It's a very
ruled.
important question you're asking. Give me 1 minute, 60 seconds. It's an old favorite of mine for last 5-7 years. I say it like this: the threat to free speech is not governmental so much, not external so much, not censorship so much. The biggest threat to free speech, and I'm saying generally philosophically, is our compulsion to conform. We are under compulsion to conform, and the conformism norms are set by you. By you, I mean the media.
You're saying the judges buckled under media pressure
no, I
in
didn't
the
say that.
Sabrimala
That's
case.
your words.
But
That's your words.
That's what you said.
I am saying, no,
the
I'm saying.
The press set standards for the
saying,
court, and I believe this was definitely a factor in the way the court ruled. That means the court buckled
Unpopular,
under the press.
No, buckled is your word.
Obviously.
No.
Use any other word. The court ruled and came up with a judgment under pressure of the press. It couldn't stand up to the press criticizing it for doing the opposite.
Compulsion to conform means that in our subconscious, we tend to want to do the proper thing more than the right thing. Even if you believe that the constitutional text compels you to take an unpopular view, you may well take a view which seems the proper view. And the proper view, unfortunately, in this time of 24/7, with including anchors like you breathing down our neck, all of us want to conform to the ethic which you set for us. This is an external ethic, and we believe that we are anti-women. I'm not saying this bench, I'm saying generally. I conform to a lot of things because I believe it's the proper thing to say.
Mr. Singhvi.
I tell you,
Mr.
one of the reasons why a person like Trump.
Permit me a moment. Yes. I've listened to you with great interest. I quoted to you what you wrote about the Supreme Court, but when I brought up examples to illustrate, you began defending the court and criticizing me. And yet, you were the one who I was quoting because you said the Supreme Court has ceased to be fearless, it's ceased to be independent.
I'm saying
it
myself
actually deliberately deferred.
In the
all the examples I brought up, you started defending the court. And now again, you're the one who said that the court has acted under pressure of the press. The second I bring it up and suggest this means the court's buckled under pressure, once again, you begin defending the court. You're not actually standing by all the things you've written.
On the contrary, I'm criticizing the court. Just now, a moment ago, I said compulsion to conform. Compulsion to conform is not about this judge, that issue. It's a general overweening pressure of the press on all of us, which makes us write what we think is a particular form of liberalism, a particular form of stand, and not take the strictly legal view.
The sentence I quoted was not a general sentence about the court.
No, it's about Sabrimala.
Absolutely. And you said there was no way to give a verdict other than the one the press wanted, otherwise you'd be painted regressive.
That's the meaning of compulsion to
conform. So
they
buckled under press pressure.
It's your words you can use.
It doesn't matter my words, that's what you're saying.
To suggest that the strict letter of the law permits a nexus between fertile women and a nesting brahmacharya, and therefore the exclusion is justified, might well seem like regressive.
I have to tell you one thing, and I'm saying it with irony. The critique that I read in this book of the Supreme Court and the judicial system,
was for the last 3 years.
Struck me out, whether it was from last year or not.
Obviously, you were asking about current years.
Look, the book's just come out. The book didn't come out last year. The book came out last week.
No, it stopped 3 weeks, 3 months ago.
Then you should have put a big thing over here which said, I'm only talking about Justice Gogoi, not Bobde. No. Because what emerges is that you've been critical in the book, but in the interview, you're a defender of the faith.
I am a defender of the faith because I have faith in the institution.
All right.
I'm certainly not a person who has no faith in the institution. I believe it requires constructive reform. And constructive reform is not by a blanket denunciation as you've been doing. It is by a nuanced criticism of a constructive kind. There has been a decline. Previous years before that were glorious.
Let me leave the audience with a compliment for you.
Yes.
Let me leave the audience with a compliment for you. The Abhishek Singhvi who emerges in these pages that he wrote as a strong critic at times of the Supreme Court is very different to the Abhishek Singhvi you heard. I suggest you read the book and pay less attention to the man sitting in front of me. But he's smiling and he's laughing and he knows that he's enjoyed a thoroughly good conversation. A pleasure talking to you.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.